when the 2014 results comes out,
and assuming they did not file a representation, but presuming that, let us say I am the board, and some people, these genuine people, have made a representation to me. I acknowledge my mistake. Yes, one question was wrong, and I give 1 mark. What is wrong with it?
wrong is, but if I find that one question was wrong, then it's my duty to make known to everybody.
You are right. They are wrong.
That's the fundamental.
But that this wrong has been committed by board, not by them.
I say, well, board. I say, well, they are the beneficiary of, without, if you may say wrong, you may say fraud, whatever it might be, of the board. But the beneficiary of a
this the board has to answer.
It is. Well, the beneficiary of a particular action will cannot say, I'm not to do against them. If they get a job,
and how many of those candidates should be 20 lakh? 20 lakh appeared in the exam. And who qualified?
30 lakhs or 12 lakh appeared, 1 lakh 25 qualified. The rest are there.
1 lakh 25 qualified, nobody has any problem with that. Yeah. When you are saying 1 mark short, you'll ask how many?
20 lakhs? No, that is the affidavit also. They hardly ask first.
So this
board or any authority, the appointing authority, should be fair to everybody. Because that's why I say
that 20 lakh. Those 20 lakh have to ask.
I might number
use the number 30. Only 1 lakh
20 lakh who applied.
30 lakhs. 30 lakhs of the exam.
Out of 30 lakhs, out of 13 lakhs, 1 lakh have qualified, no problem, they have got. Out of 30 letters, 12 lakh are just round figure.
Yes.
Why did you give 8 marks?
But that is for the remaining 4 candidates.
No. Page 6, paragraph 17 of the page 6. Volume 4. In order to resolve the dispute.
No, 1 minute. It's not matching.
No, that will match without the
Volume 4.
Yes, para
17.
Page 6, right? In order to resolve.
In order to resolve the dispute on 16 November, the Secretary of the Board called for an emergency meeting of the other committee of the board and to decide the matter of some applications submitted to the board. But this is the some applications on which board took decision. And that's why no record has been disclosed. Nothing is there. Including the read petitioners before the Honorable High Court so and so relating to questions of TET 2014. Then kindly come to Lord, paragraph 19. It is stated that after receiving approval from the state government for the recommendation made by the board, the Secretary of the Board notified another meeting on 28th November to consider approval of an additional plan in terms of the resolution of the ad hoc committee. It is stated that in the meeting as scheduled, the Secretary of the Board submitted a note in terms of the approval of the state government. As per the note, 270 applicants having relevant teacher training qualification. That's why the division bench took serious exception, saying there was a public notification. And that's why without all this suppression before the division bench while the proceedings are continuing. They have never said so anywhere. But that is Mr. Gupta Milord is making a statement before the court. In the affidavit, that is Milord very glaringly absent.
You're misreading the affidavit. Para 8 is very.
Okay, we'll hear Mr. Gupta on that.
Problem is this, my lord, when my learned friend starts hammering a particular point, I have to go back and take instruction. I made it clear what I thought in para 22. My learned friend says point is not clear. So, my lord, I have to go back and take instructions to make sure that what I thought I was writing in para 22 is the correct thing.
You ask your,
I have asked.
your junior to keep a hotline on.
Yes,
Instructing officer.
he is in fact or not. Because just now, my lord, he has disappeared for good, my lord. So I don't know when he is.
Whoever is.
It's quite interesting.
And then the kind
My friend read para 7.
difficulties Milord,
Anyway, let him finish.
every time they will stand up.
No.
Well, unless if I am not allowed Milord, time uninterrupted, I cannot finish it. They are not interrupting deliberately.
Yes.
But kindly come to now read paragraph 8 at page 15.
Page 15.
Page 15 of.
Page 15 of volume 4. The affidavit, same affidavit of the board. Now, the affidavit cannot be subsequently improved by taking instructions. Kindly allow me to read it. In consideration of several representations from the candidates belonging to various districts, board resolved to send the said question and transfer key there to the expert committee on school education. Therefore, everything, my lord, is done, and that is also, my lord, corroborated by their own affidavit that we were agitating, and the board said file application. Well, that kindly takes up the affidavit filed by the candidates who are taking the benefit of this appointment, which was filed before the High Court after the Honorable Court's direction. There they say, kindly come to volume 2, 1294. Well, that is the first hand, my lord, experience of those candidates. Kindly takes up, my lord, once again. I'm sorry to, my lord, go back to this page 1294.
Of volume?
Volume 2A.
Page?
Like page 1295, subparagraph M, where from it starts that they did not qualify in TET 2014. And then kindly come to subparagraph P, several candidates, including myself, being agreed by the actions of the board, held peaceful agitation for publication of our result, including our marks. And then at this stage, representative of the board requested the agitating candidates submit their grievance in writing and assured that their demand would be considered. It is under these circumstances I gave memorandum of grievance of the board wherein I had demanded inter alia so and so. Then paragraph S. In May 17, I received the text message which I placed before Lordship. It transpired the same had been sent by the board and it was addressed to the candidates. Then without I received the telephone call on December 17 and appointment. But these I have already pasted. If these are the facts, I don't know what else could be more glaring to interfere with these appointments. Now the question comes, I shall conclude by saying, they say, now the division bench has said 6 marks to all. But if giving 6 marks to all, board wants to start the selection process in accordance with law, there is no bar. But this appointment cannot continue. The learned judge has done the same thing with regard to one candidate. That your earlier appointment is bad, it is set aside. Now, by virtue of 6 marks, if you get an appointment, you will get fresh appointment. Give order, please. Page 29. Page 29. Page 29. Well, after my lord's direction, they appeared before the court, some filed affidavit, and in one case, who produced that I had OMR sheet on my application before the RTI authority, court considered that and found that yes, you had genuinely applied. And in that case, court said, kindly come to, I'm paragraph chahiye. Yes, kindly come to that page 920,
Same, volume 2A.
volume 2. This is the below application filed by them seeking permission to bring on record additional facts. Page 920. Respondent number 306 at page 920.
That's volume two.
That's volume 2.
The new volume. It is 975.
That's your application for additional.
97515 volume.
Now, my lord, as is got it.
Yes.
Now, the respondent number 306.
Yes.
Page 6.
Mark this volume.
We marked it as 2.
Mark as 2.
Yes.
This is the judgment.
Has filed an affidavit. In the said affidavit, there is a representation, and you note this. And it has been shown to me that the representative was sent by the registered speech post to the Secretary of the West Bengal Primary Education Board on 15 June 17. The date of the representation is 14 June 17. But there is no decision of the board that 1 mark will be awarded to her for declaring her as qualified candidate of TET 2014. But she was given the job. The respondent submitted that she filed one writ application, and after receiving this writ application, the board gave her appointment after giving her 1 mark, and she joined the school on 6 December 2017. She was called to the office of the board and recommendation was given. As there was no provision for giving appointments to individuals in such a way, i.e. calling a person or intimating a person through others for coming to the office of the board, and then her testimonials would be scrutinized and examined, and then she would be granted an appointment, the entire law in respect of such recommendation and appointment has been flouted in the case of the respondent's appointment. Therefore, despite the respondent made a representation, no reply was given to her. It was only whispered in some special years for giving 1 mark to the respondent, which is most illegal. In fact, the respondent's name was included in the second panel, which was also an illegally prepared and published panel. Therefore, the employment of the respondent is cancelled, and she shall not enter the school premises from today itself and shall not sign any paper document so and so. Then next paragraph. Whether the petitioner, being the respondent 306, will be liable to pay the entire amount of money she received as teacher against such illegal appointment will be decided later. But the matter cannot stop here. The respondent filed one writ petition alleging that she should be given full marks to question number 6 to 22 of the question booklet so and so. It has been submitted on behalf of the writ petitioner that a large number of such wrong answers, key writ petitioners were filed, and in fact the respondent whose employment has been cancelled right now also filed one writ application, but thereafter there was no communication between the client and the advocate. In the meantime, it has been declared by an expert committee appointed by this court in respect of a writ application number so and so that the question number 6 and 22 were wrong. The writ application should be given 2 marks forthwith by the West Bengal Board Private Education for wrong answers key, and the respondent shall be recommended immediately, preferably in the same school where she was working as state qualified candidate. Before appointment, the board has to take one interview of the petitioner, because this appointment in connection with the writ petition would be a new appointment and will not be a continuation of the earlier appointed granted illegally. The earlier appointment has already been cancelled. Then, therefore, this 306 will not, in case filed affidavit, is just in case court granted, cancelling the earlier appointment and consider afresh. If the 6 marks is given to all, if the board wants to revise, I have no objection, but they have to follow the rules. There should be, now by giving 6 marks, they might be qualified for TET. And if they are taken qualified TET for the employment notification made in 2016, they will not, along with those candidates who were not appointed, they ought also be considered in totality. Those candidates who passed 1 of 25 candidates, they are out of consideration. because subsequently somebody made an application. No, this is wholesome illegality.
1 lakh are already in.
1,25,000 is already in. No, 40 lakhs are already in. 1,25,000 are qualified.
40,000.
Who had applied. Now, on 42,000 vacancy declared, there are only 40,000 and odd were appointed. 2,000 vacancies were kept aloof, and those 2,000 vacancies were manipulated subsequently. That is the investigation on which the court directed, and investigation results not shows. So I am not allowed to submit those. Therefore, those 1,25,000 barring 40 remains without 85. Those 85 candidates and these candidates who have got 6 marks all should be taken in a hop in a particular basket. Then the recruitment process should follow. Who stands in the way? But these illegal appointments, Lord, admittedly illegal appointments, should not be allowed to stand for the benefit of Lord, the education of the society and for benefit of the Lord,
No,
constitutional.
what's in the direction in this matter?
Directing that she will be selected, and she selected, she will have a fresh appointment. Yes, appointment can.
But fresh appointment would be in connection with the 2014 date only.
Yes, only 2014 date, nothing more than that. If they are taken to be below 2014 date qualified, and if notionally they are taken to be qualified to make application in terms of the employment
So
notification.
you mean to say, in other words, you are saying that they are also liable to get 2 marks or 6 marks or 8 marks, and therefore they are also liable to be selected.
Liable
But
part.
it will be a fresh.
Yes.
Now they have already served for 4 or 5 years.
Doesn't matter.
No, doesn't matter for you. It may not matter for them. Now for the 5 years they'll be washed out. Those 5 saal gaya.
Lord, this is the settled position of law in our
A
country.
settled position we'll see. But now this will be a fresh appointment.
Fresh.
This is your argument.
Yes, otherwise, Lord, this will be discrimination so far the others are concerned. Point out that
We can ask some question to Mr. Gupta, then you can note down, you can tell us if you.
No.
deep level. আরে ওরা কাজ করছে না কি ডিসপিউট করছে না আমি
Mr. Gupta,
না না
the first question we have from you
Yes.
is WhatsApp. Oh,
Which page is that? WhatsApp message?
SMS.
Look, that is at page
145.
145 of volume
There is no communication
Volume 1.
volume 1 145.
come to us by which you have said that